Hello, friends. Welcoming you all to the fifth session of BCAS TAX GURU-COOL. In this edition, we are going to cover the important updates and amendments which have taken place in the month of October 2018. Few selective updates which will affect or which are affecting all of us in our regular day-to-day practice. The first amendment is regarding the changes which have been brought in Form 36 and Form 36A. This amendment has happened by way of notification number 72 of 2018 dated 23rd October 2018. As you all know, Form 36 is the form in which appeal is made to tribunal against the order of the Commissioner of Income Tax. Now, this form was not amended, the format of this form was not amended since 1993. And there is also Form 36A in which cross objections are filed. Form 36A was not amended since the time of its incorporation. So now the notification brings in and amends Rule 47, whereby the format of Form 36 and 36A is amended. The important differences as compared to the earlier forms are that the fields which are provided for giving the name, address of the appellant are now structured. The information is to be given in more structured format, and in addition to the information of name and address, even the new form requires the email ID as well as the phone number of the appellant. Now, this is in line with the initiative of CBDT to do e-assessments, send notices in e-manner, and thereby the email address is sought in this form. One more important amendment which has been done in the format is that in this form where appeal relates to the assessment, any additions, disallowances made in the assessment, the form requires you to give the nature and brief of the disallowance, the amount of addition made by the assessing officer, out of that the amount of addition disputed by the assessee, and the tax effect on this addition or disallowance which is disputed. Up till now, the form only required you to give the ground and the amount of dispute. Now, in this new format, additional details of the total addition disallowance is made. Out of that, what amount is disputed and what is the tax effect of such dispute is required to be mentioned ground by ground. Now, what is the amount of tax disputed? The instructions or the notification, which is notification number 72, elaborately explains how the tax effect or how the tax on the disputed amount is going to be calculated. The circular says that the amount of tax on the disputed addition will be the amount on the assessed income reduced by the amount of income, assuming that the amount of addition which is disputed was not made to income. So in nutshell, the definition of amount which is sought to be evaded or the amount on which tax is disputed is similar to the definition or the meaning given in section 271(1)(c), whereby the amount is calculated for levy of penalty. The circular further states that when you are going to calculate tax effect on the amount disputed, the tax effect includes the tax at prescribed rate, it would include surcharge and education cess as per applicable rates, but it does not include interest unless the interest itself is the ground which is in dispute. So therefore, with this clarification, there should be less amount of gray area while the tax on disputed amount is going to be calculated. Similar changes are also made in Form 36A, whereby the details of name, address, email, and mobile number are to be given, and cross objections can be filed. The tax, the appeal in Form 36 as well as 36A requires to give information whether the appeal is filed within the prescribed period, and if there is delay in filing appeal beyond the prescribed time limit, then the form requires that the affidavit explaining the reasons for seeking condonation of delay be attached with the form itself. Earlier, the affidavit used to be submitted by the assessee at the hearing before the members. Now it is to be attached with the form itself. There is one more change by another notification, notification number 73 of 2018, dated 23rd October 2018. This notification amends Rule 14 of DRP rules to provide that any appeal arising out of DRP order before the tribunal will also now be made in Form 36A and not 36B, which was hitherto used by the assessees. So now we will have only Form 36 for appeals filed to tribunal and Form 36A for cross objections to be filed before the tribunal. This brings us to the second notification which has been issued by CBDT, notification number 74 of 2018, dated 25th October 2018. This notification relates to online application made for obtaining certificate for lower deduction of tax or lower collection of tax at source. We all are aware that presently the assessee had to make an application in Form 13 to the assessing officer to obtain a certificate from him authorizing the assessee to receive income without deduction of tax at source under Section 197, or for deducting tax for lower collection of tax at source under Section 206C of the Act. Now, in line with the initiative of going digital, the notification prescribes that the application in form number 13 will now be done online with digital signature or by verification with one of the digital modes. Once the application is filed online, in which the name, address, TAN number, etc. of the person from whom income is to be received is given in the form, then the officer will verify the details and issue a certificate directly to the payer, authorizing him to pay the applicant the amount either without deduction of tax at source or after deduction of tax at source at lower rates. Now, this certificate will be issued by the officer also online. So, therefore, there will be no need to visit the office to obtain the certificate of lower deduction of tax or lower collection of tax. The notification further prescribes that there could be a situation where there are more than 100 parties from whom the assessee or the applicant is going to receive the income, and in such case the assessee or the applicant would not be in a position to gather the PAN number and TAN number of all the persons from whom he is going to receive income during the whole year, and therefore such details cannot be filled in the form which is filed in a form, the form online filed in form number 13. Recognizing this situation, the notification provides that where there are more than 100 parties from whom income is receivable and the assessee does not have the details of PAN or TAN of these paying parties as on the date of filing application, the application can still be made with a declaration to that effect, and in that case, the assessing officer will issue a certificate authorizing the applicant to receive income without deduction of tax at source or after deduction of tax at source at lower rate. So this certificate then the applicant can issue to various parties from whom he is going to receive income during the whole year. Of course, as earlier provided in the rules, the certificate will be valid for the period mentioned in the certificate, and typically it is valid for the financial year for which certificate is issued. Let's come to the next notification or the circular which is issued by the CBDT. CBDT has on 29th October 2018 proposed draft rules for e-filing of application for seeking approval under section 1023C or 80G. As we all know, up till now, application for seeking approval under 1023C was to be made in Form 56 or Form 56D. Application for getting approval under Section 80G was to be made in Form 10G. These applications were filed manually along with all enclosure with the relevant officer. The CBDT has now prescribed draft rules, and these rules are kept before general public for the comments. Up to 13th November, the general public can provide their comments, suggestion for the initiative of this e-application, and thereafter CBDT will issue the final rules for e-filing of applications for approval under 1023C and 80G. After these notifications and updates from CBDT, now let's turn to the important decisions, few of the important decisions which have been pronounced by various courts during the month of October and which will be helpful to all of us during our day-to-day practice. Let's take the first case of Bhupendra Murji Shah versus DCIT, the decision of Bombay High Court. In this decision, the Bombay High Court has given its views regarding the instructions which CBDT has issued dated 29 February 2016 regarding payment of 20% of the demand amount so that the stay can be given or stay can be obtained for balance amount of demand raised by the assessing officer. In this case, a very high-pitched assessment was done. Assessee had filed an appeal. The appeal was pending hearing, and in pendency of appeal, the assessee was told to pay 20% of demand to get stay for the balance amount. The assessee filed an application for stay of demand before the commissioner, but the assessing officer informed him that in view of the CBDT instructions dated 29 February 2016, there is no other option for the assessee than to pay 20% of the demand amount to seek stay for the balance amount, which really means that there is no alternative for the assessee to explore the alternate remedy of seeking stay for the entire amount of demand. Assessee therefore filed a writ petition before the Bombay High Court in which the facts were explained to the court, and the court said that the CBDT instructions which generalize a situation and whereby the assessee is required to pay 20% of the demand pending the disposal of appeal is really not the intention, cannot never be mandated by law, and it is actually frustrating the right of the assessee to seek protection against the collection and recovery of the pending appeal. Therefore, the Bombay High Court said that the assessee should always have a right to to make an application before the higher authorities to seek stay of the entire amount of demand. Proceeding further on the specific facts of the case, the High Court said that in this case, because the appeal is actually heard by the Commissioner, it's part heard today, the next date of hearing is approaching soon, and due to these specific facts, and because the assessee has given a specific undertaking that he would not create any third party rights in his movable assets and properties till the appeal is finally disposed of, the Bombay High Court said that considering these specific facts, the assessee may not be compelled to pay 20% of the demand, but the entire demand should be stayed. But mind you, while giving this decision, the Bombay High Court has clearly said that this decision we are giving considering the specific facts of the case, and this does not lay down a precedent for all years to come. So while applying this decision, one needs to carefully understand the facts and then rely on the decision. After that, let's go to the next decision of Supernova Systems Private Limited. It is a decision of Gujarat High Court which deals with the issue which is presently very widely experienced by all regarding compounding of offenses. In this present case, the issue before the court is that what is the amount sought to be evaded, which is mentioned under section 276 of the Act. Provisions of the section 276 state that when there is any willful attempt by the assessee to evade tax, then in addition to the penalty which will be levied, the assessing officer can further levy the amount of fine as well as there is a provision for prosecution. And section 279 gives powers to the principal commissioner or the principal director or the director of income tax to provide or give relief by compounding of offense. When we refer to the provisions whereby the compounding is referred to, the compounding is permitted and the amount to be paid for compounding is 100% of the amount sought to be evaded. And the issue before the court was as to whether it is amount for which the addition is made by the assessing officer. So is it the amount of income which is sought to be evaded, or it is the amount of tax on the amount sought to be evaded? The wording of the section is a little vague and therefore the matter reached High Court. And in this, considering the provisions, the intent and the language of section 276C, the Gujarat High Court held that the amount sought to be evaded should be interpreted as amount of tax sought to be evaded. And therefore, it is not the amount for which addition is made by the assessing officer, but it is amount of tax on such income. Thereafter, let's look at the case of Mysore Datta Polymers Private Limited. It is a decision of Bangalore Tribunal in ITA number 2403, Bangalore 2018, in which the issue before tribunal was that when there is an intimation issued by CPC under section 143(1), in which certain additions or disallowances are made, an assessee is to file an appeal before the commissioner against the disallowances or additions made in the intimation, whether there is a requirement to separately attach a notice of demand issued under section 156 along with the form of appeal in form 30Y. In the present case, because the appeal was filed against the intimation issued by CPC, and in the intimation it is clearly written that it is to be treated as the notice of demand and payment of this demand raise has to be paid within 30 days of receipt of this. The assessee had filed the appeal and stated that this intimation itself constitutes a notice of demand, and therefore no separate notice of demand is required to be attached while filing the appeal form. The CIT appeal did not entertain this appeal by treating it as defective, because in his view the notice of demand was not attached with the appeal. The Bangalore tribunal, after considering the facts of the case, held that the intimation issued by CPC under 143(1) itself is a notice of demand, and therefore no separate notice of demand is required to be attached with the appeal, and the matter was set aside to the CIT to admit the appeal and thereafter decide on the merits of the case. This decision is useful to all of us, because while the intimations are issued by CPC and appeals are filed against such appeals, sometimes CITs can take a stand that the appeals are defective. This decision will be useful against while arguing that no separate notice of demand is required to be attached with the appeal. With this, it brings us to the end of this fifth edition of Tax Gurukul. I thank all of you for tuning in. Let me take this occasion to wish all of you a very happy Diwali. Let the festival of light bring lots of happiness, prosperity, and good health to all of us. Thank you once again.